My lords, the former Chief Justices of Nigeria, Honorable Mr. Justice S.M.A. Balgore, GCON, and Mahmoud Muhammad, GCON, my brother justices of the Supreme Court, serving and retired, President and Honorable Justices of the Court of Appeal, serving and retired, here present, courts of various jurisdictions, my lords, judges of various jurisdictions, including Cadiz and Grand Cadiz, the Honorable Attorney General of the Federation and Minister of Justice, here represented by the Solicitor General of the Federation, Shomole, members of the Inner and Outer Bar, the President, the Administrator, National Judicial Institute, our esteemed royal fathers here present, family members of the awardees, distinguished invited guests, gentlemen of the press, ladies and gentlemen. It is a great privilege and opportunity to mark the commencement of the 2018-2019 legal year. Therefore, on behalf of the Supreme Court of Nigeria, I extend a warm welcome to everyone present at this auspicious occasion. As we all know, this unique occasion is celebrated alongside the swearing-in of deserving members of the Nigerian Bar, conferred with the prestigious rank of Senior Advocate of Nigeria, SAN. Certainly, the 2017 league, an occasion like this gives us the opportunity to reflect and examine the activities of the last 1 year with the aim of paving the way for a robust legal year by building on the previous landmark achievements and avoiding a repetition of past mistakes. The judiciary, to a large extent, was successfully responding to the challenges it faced towards maintaining its independence and protecting its impartiality. May I therefore use this medium to commend my learned brother justices for their courage, resilience, and expertise in the handling of cases. We have worked together as a team to pilot the affairs of the apex court of the land. I am optimistic that we shall demonstrate more commitment and hard work in the course of this new legal year. I wish also to recognize the efforts of all those, both within and outside the judiciary, who have been very instrumental in rebuilding the judiciary. Indeed, their unwavering support and partnership have given birth to an justice delivery system. Appointments, retirements, and passages, 2017 to 2018 legal year. On 27 February 2018, Honorable Justice Clara Bata Ogumbiyi's sterling career as a judicial officer came in as she gracefully retired into a well-deserved era of rest and private life. We wish her good health and God's. Sadly, however, we recall the passing of two seasoned jurists, both former Chief Justice of Nigeria. I refer to the Honorable Mr. Justice Dahiru Mustafa, GCON, who died on January 22, 2018 at the age of 75 years, and the Honorable Mr. Justice Kassina Alu, who died on 18 July 2018 at the age of 76 years. The leadership that both jurists provided to the Nigerian judiciary and the Supreme Court in particular during the Chief Justice of Nigeria was impactful and profound. They are and will continue to be invaluable references, both in advocacy and the practice of law in this country. We also lost 4 of our brothers and retired justices of the Supreme Court, namely Honorable Mr. Justice Sifulai Muntaka Kumasi, on Friday, October 13, 2017, at the age of 71 years. Honorable Mr. Justice Pius Olayiwola Aderemi, who passed away on Monday, June 18, at the age of 79 years. Recently, Honorable Mr. Justice Dennis O. Edozie answered the call on 18 August 2018 at the age of 82. And just last week, my senior brother, Honorable Mr. Justice Ikechi Francis Obuagu, CON, passed away at the age of 78 years. We thank God for their worthy and noble lives and the privilege of having them in our midst. With full repose of their gentle souls and comfort for their families. On personal level, I lost a mentor, Honorable Mr. Justice Mohammed Mustafa Akombi, CFR, former President of the Court of Appeal and former Chairman, Independent Corrupt Practice Offenses Commission, ICPC. On 3rd June 19, agree with me, we lost one of the time whose enduring legacies we will cherish for a long time. May God grant his noble soul the rest is so deserved. Review of 2017-2018 legal year. In the course of the 2017-2018 legal year, the Supreme Court of 540 matters, comprising motions, appeals under motion 824 civil and 200 criminal motions, totaling 1,097. Also consider a total 38 appeals comprising 192 criminal. A total of 297 judgments were delivered by the close of 2017-2018 legal year. This is by all means an impressive, considering the persistent and increasing volume of cases that before this court. I attribute this impressive performance to the hard work of judicial officers, support staff, and the reforms we are implementing to improve justice delivery. As we sit daily and sometimes conduct special sittings to clear backlog of cases, we remain committed to expeditious dispensation of justice. I would like, therefore, to once again salute and thank my learned brother justices for their continued commitment and hard work. As we acknowledge noticeable improvement in the disposition of cases, we are not resting on our laurels. This court will therefore continue to strive for speedy disposal of cases that come before it. On the international scene, our reform efforts are recognized and rewarded. I was recently conferred with the Michael Hill Prize by the International Society for the Reform of Criminal Law in Montreal at the launch of the Global Judicial Integrity Network by the United Nations Office on Drugs in April 2018, amongst others. I am happy to inform you that one of our judges, Honorable Mr. Justice Kashim Zana, Chief Judge of Borno State, was nominated to serve on the advisory board of this important body. 2018-2019 legal year in focus. In my speech at the commencement of 2017-2018 legal year, I stated that my primary concern is, inter alia, to ensure progressive upgrade of the judiciary, especially in areas of administration, practice directions, independence of the judiciary, and contributing significantly to the fight against corruption. I also emphasize that justice must not only be done, but must be manifestly seen to be done. While our quest for a vastly improved and ICT-driven judiciary has achieved commendable milestones, I must state here that much work still needs to be done in order to improve our administration of justice, particularly as regards stricter timeliness, engagement, enhancing IT presence, the independence of the judiciary, and strengthening judicial standards and ethics. Administration of justice. In order to enhance the administration of justice in Nigeria, we are constituting a national committee on rules of practice and procedure made up of judicial officers, legal practitioners from the local chapters of the Nigerian Bar, academics, system of partial front-loading, which covers pleading of facts and law. Evidence should also be included. The rules of practice and procedure should make provision for consider that the appellate system should be strengthened by enabling procedure to provide for the award of punitive or by the court for frivolous or delays caused by counsel. Rules of court must provide for the mandatory keeping of court diary, not only by the registrar of court, but also by the judicial officers. Where information and communication technology is available and applicable, there must be computerized records to each court. Entries must also be made and posted on the website of the judiciary, where information on the type of cases, progress made, judgments, etc., can be accessed anywhere in Nigeria, monthly or quarterly. Council will write to within the state to avoid between the Court of Appeal of the customary Court of Appeal, where there is and the bench should ensure that they play their roles in restoring ethics to the National Executive Committee of the Bar should enforce cases that are ongoing. The Educational Committee of National Judicial Institute should include in its curriculum issues that would sensitize judicial officers on the need to be cautious in having improper communication with counsel appearing before them. Finally, there is need in the use of alternative mechanisms as a means of justice. And more importantly, investor confidence in ICON. As we prepare for the 2019 general elections, I reiterate that in determining electoral disputes, continue to play the role of independent, dispassionate arbiter without fear or favor, affection, or ill will. However, the bar must partner with key stakeholders to play the critical role of sensitization and voter education to ensure that eligible members of the public are properly enlightened on the need to participate in the process and conduct themselves lawfully. Such peaceful and largely accepted electoral outcome will engender peace and stability in the politics. It is also a justice system will therefore enhance justice by ensuring, for example, that information is adequately captured and passed on digitally. Data exchange will not be disintegrated and court processes will be finalized and ready on demand. I believe rather than point accusing fingers at the courts, we should all take collective responsibility for this problem and chart innovative practical solutions. To what extent, for example, can judicial processes be fast-tracked with information technology, unwittingly excluding or punishing litigants to negative IT, that is information technology? With the e-justice system, case management will be automated. Payment of fees will be made through dedicated websites to reduce corruption, and forms that simplify and streamline court proceedings will be available to court users online. However, such measures must be accompanied by enhanced capacity of personnel and investments in cybersecurity. There is no doubt that an independent, technology-driven justice system is fundamental to ensuring the establishment and of sustainable institutions. During the 2017-2018 legal year, the following milestones were recorded. 1, newly retrofitted court at the Supreme Court of Nigeria. The year witnessed the commencement of court proceedings in the newly retrofitted courtroom of the Supreme Court of Nigeria. All court proceedings are available on high-quality video format with FTR recording equipment. This has greatly assisted in obtaining real-time transcription of court proceedings. Legal year email system, Nigerian legal email system. The Supreme Court of Nigeria had commenced the implementation of 7 hearing notices through the Nigerian legal email system. This process came into force on July 16, 2018. Every registered lawyer on the platform gets immediate proof of service on sending email to the court using their legal address. The Supreme Court of Nigeria is expected to enroll for this service in order to be properly served. At present, 23,000 lawyers have been registered for the email and 18,000 activated on the platform. In addition, 5,250 email addresses are available for court staff. It is expected that some correspondences should now be sent by official email. That is court.govng. A court policy will soon be developed in this regard. 3, Nigeria Case Management System. New cases are currently being filed in the case management system. This is equipped with new audio-visual technology equipment and big smart LED screens for court events. By projecting the time base, the cost list of the Supreme Court for December to December 2018 are already on our website. You may confirm it right now. 6, presence on social media. For effective dissemination of information on Supreme Court of Nigerian operations and events, Twitter handle and YouTube accounts have been created in addition to the court website. This will enable the court to reach the litigation world through social media. Our Twitter at Supreme Court NG, and the YouTube channel is Supreme Court of Nigeria Media. These mediums will be updated on a continuous basis to disseminate to litigants and the public at large. In the same vein, the National Judicial Institute has intensified IT training for existing judicial officers, judges of lower courts, and other staff of the judiciary. I therefore enjoin enjoin all judges and lawyers to join the judiciary's quest for excellence by subscribing to and acquiring the legal email, as manual forms of communication will soon be phased out. Lawyers who have acquired the legal email can henceforth communicate electronically with the courts and with each other. The fight against corruption. As stated in my speech last year, an anti-corruption case trial monitoring committee, COMTRICO, was constituted under the chairmanship of Honorable Mr. Justice Suleiman Galadima, JSC, retired, OFR, CFR. The committee was set up to make cases in various courts across the country, in line with my directive to all heads of courts to designate special courts in their various jurisdictions for the speedy trial of corruption cases. I am happy to inform you, at the end of the last legal year, a total of 1,499 such cases were identified. Out of this number, a total of 345 judgments were delivered, 14 cases reserved for judgment, and 12 cases struck out. 1,139 are seen in various courts across the country. This is a remarkable achievement and a testament to the resolve of the judiciary to fight corruption in our nation. We have a lot more in our agenda to strengthen and reposition the judiciary, but suffice it to say that fighting corruption is not the responsibility of any government, but that of every Nigeria. Corruption or any other form, for that matter, thrives in a culture of impunity. To carry out a successful campaign against corruption, we have to fight the culture of impunity, which is an attitudinal phenomenon. If we allow and respect the rule of law, then there will be a dramatic reduction in corruption and injustice. Corruption starts with a decision by an individual or a group of individuals to do the wrong thing. It is as simple as that. It's never an accidental act. The person who comes has an option to do the right thing. As a democracy, Nigeria is guided by the rule of law, where the constitution is the ground norm. And let me quickly add that there is no ambiguity as regards the role of the judiciary in an arbiter at any point is to be done. Corruption, a justice or a panel, having heard from all parties and having determined where justice lies, decides to do the wrong thing by giving judgment to favor a particular party or another. We must not lose sight of the indispensable judiciary in the fight against corruption. Corruption continues to place the judiciary in the eye of the storm, but we cannot allow that to deter us or weaken our resolve. We must resist all attempts by the rapacious elite to make justice a commercial commodity. This is an imperative if democracy is to be sustained in our country, where the free market milieu seems to be promoting an alarming notion that there is a price tag for everything. We must accept that acts of misconduct of a few rub off on the rest of the judiciary and create the impression that all judicial officers have their hands soiled with the process of corruption. As Henry Ward Beecher sagely observed, and I quote, "Take all the robes of all the good judges that have ever lived on the face of the earth, and they will not be large enough to cover the iniquity of one corrupt judge," unquote. It is therefore imperative that anti-corruption initiatives must embrace proactive as well as consequential measures. Indeed, the National Judicial Council is determined to redress proven cases of judicial corruption with swift and decisive measures. 6 months after inauguration, Contrico came out with an interim report that indicted almost everyone in the justice delivery chain: prosecutors, investigating agencies, lawyers, counsel, judges, and prison authorities, among others. The committee's reports distilled a problem ranging from poor prosecution, duplication of charges, multiplicity of cases, absence of parties in court, extrajudicial statements, lack of relevant documentary evidence, and on the part of the court, he identified the following as contributing to delay in quick dispensation of corruption cases: retirement, transfer of judges handling such cases, granting of remand order by a court without following up to ensure suspects are brought to court, inadequate provision for proper record keeping, cumbersome process of transmission of records from trial court, which impedes the early disposal of appeals, and difficulties associated with ascertaining addresses for service of processes by bailiffs. The committee also made far-reaching recommendations for speedy trial of corruption cases, which I have adapted and implemented. We in the Supreme Court haven't reduced the pre-election appeals in the course of the third term. We'll devote much of this first term in dealing with the identified EFCC, ICPC, and economic crime cases along the normal civil, criminal, and political cases. We shall continue to strengthen the judicial institutions in the performance of their statutory functions. We shall reform, strengthen, and continue to work with the National Judicial Council and with the support of the public, rid the judiciary of both perceived and real corruption. New senior advocates of Nigeria. As with our tradition, today we confer the of our profession on the most deserving members of the Nigerian bar. This year, 31 legal practitioners were nominated for the award of the rank of Senior Advocate of Nigeria on 12 July 2018. However, only 31 will be conferred or had been so conferred with a prestigious rank today. Based on petition against one of the awardees, and by 5 of the legal practitioners asked Laws of the Federation of Nigeria 2004 as amended, the Privileges Committee at an emergency meeting held on Thursday, 20th September 2018, to consider the petition and the written reply by the respondent, decided to withdraw the nomination of Ikedia Eleodua Esquire for the conferment of the rank of Senior Advocate of Nigeria. The committee also barred the legal practitioner from applying for the rank for the next 5 years, or 5 applications beginning from 2019. By virtue of the provision of Section 5 of the Legal Practitioners Act, Cap L 11, Laws of the Federation of Nigeria 2004 as amended, the Legal Practitioner Privileges Committee has the sole responsibility to confer on legal practitioners the rank of Senior Advocate of Nigeria, SAN. The rank is the zenith of legal practice and the highest honor conferred by this noble profession. It is a rare privilege bestowed on eminently deserving men who have distinguished themselves in the knowledge, practice of, and control, having passed through vigorous processes. I am aware of the meticulous and are subjected to in line with the minimum standards of competence provided by the published new guidelines for the conferment of the award of the rank of Senior Advocate of Nigeria. First time commence in achieved by the newly appointed senior. The appointment since last year will continue to be credible and transparent as laid down by the Legal Practitioner Privileges Committee guide. And need processes set with us was accepted personal income payments. It was a new requirement for all advocate applicants to provide evidence of letters of employment. The essence of these standard of legal practice. The rank is a privilege. It is bestowed on you to show great leadership, integrity, humility, exemplary character, and be a role model to all aspiring lawyers and the public at large. I am confident that you all will live up to our expectations. It is imperative to state here again that this rare privilege can and shall be withdrawn if abused. It must therefore be guarded jealously. I must also stress that as members of the inner bar, you now occupy positions of trust and great responsibility. Expectedly, you must exhibit every virtue of excellence, integrity, and diligence at all times. You must also remember your duties to the court as custodians of justice. I have to point out the fact that in the just concluded exercise, some applicants were found to have engaged in dishonorable conduct, such as forgery of judgments, resulting in their being reported to the police for investigation and possible prosecution. We have to know that if one is not for any reason qualified to wear silk as a judicial officer, he cannot wear it as a senior advocate of Nigeria. I would like at this point to thank the distinguished members of the Legal Practitioners Privileges Committee tasked with the assignment of scrutinizing judgments, trial proceedings, and publications, and at the same time conduct disciplinary proceedings on petitions received against senior advocates of Nigeria. I am also happy to report that for the first time, you all attended a pre-conferment induction program organized and conducted by the Body of Senior Advocates of Nigeria, BOSAN. The decision to organize the induction course was taken at the inaugural meeting of the body held in Lagos. The report of the first induction program with the theme Legal Ethics and Professionalism in the Practice of Law indicates that it is a very timely and useful exercise that must be sustained to deepen the rules of professional ethics and conduct in the legal profession and to arrest the declining standard of the practice of law in Nigeria. It is my hope that the impact of your pre-conferment induction will be seen and felt by all in the years to come. Let me further state here that the Board of Governors of the National Judicial Institute has been enjoined to emphasize the need for frequent bar bench meetings, as this will lead to better relationship between the bar and the bench. This sort of collaboration can only strengthen our institutions and bring out the best in us. Ours is not called a noble profession by accident. It is truly noble. Don't you ever forget that. I therefore congratulate you all as worthy recipients of this great honor, which continues to represent the best and the noblest of the tradition, practice, and integrity of our profession. I wish you success in all your future endeavors, including that of being role models. Conclusion. My lords, distinguished ladies and gentlemen, while we are not unmindful of the challenges facing the judiciary and dispensation of justice, we are strong in our conviction that we are able to meet these challenges. The 2018-2019 legal year will, by the grace of God, be a great year for the judiciary as it endeavors to deliver justice to all. We therefore commence this legal year with renewed hope and vigor. And without any doubt, I want to confidently declare, on behalf of my learned brothers, that the Supreme Court will remain at the vanguard of the protection of democracy, human rights, rule of law, and expeditious dispensation of justice. This translated to violative on moral and spiritual foundations. On behalf of my brother justices of the Supreme Court, I extend our sincere gratitude to all our distinguished guests and well-wishers who are gathered here from far and near to witness this historic occasion. It is now my singular honor and privilege to declare the Supreme Court of Nigeria 2018-2019 legal year open. I wish you all a fruitful and happy new legal year. Thank you, and God bless us all. Amen. May we now hear the address of the Honorable Attorney General, Mr. Attorney General of the Federation and Minister of Justice, who is, I understand, is represented this afternoon by the Solicitor General of the Federation. My attention has just been drawn to the fact that the chairman of INEC, so in our midst. Prof, you are welcome. I hope we won't bore you with plenty of grammar. But being a prof, you should understand, and I know you would. Thank you. Yes.
My Lord, the Chief Justice of Nigeria, Honorable Justice Walter S. Onogo, GCON. My Lord, the former Chief Justice of Nigeria. My Lord, the Honorable Justice of the Supreme Court. The President of the Nigerian Bar Association, Mr. Paul Soro, SAN. The Senior Advocates of Nigeria. My Lord, I seek the permission to adopt the protocol by my Lord, the CJ. The Honorable Attorney General of the Federation and the Minister of Justice sent his apology. He would have been here personally, but for an unofficial trip to New York with the Mr. the General. And he has also directed me, while sending his apology, he also directed me to read his speech, and I seek the indulgence of the Lord to so do. I am indeed highly honored by your invitation to deliver this address on this occasion to mark the commencement of 2018-2019 legal year, as well as the swearing in of the newly appointed Senior Advocate of Nigeria. My Lord, distinguished ladies and gentlemen, let me commence my address by giving thanks to the Almighty, by whose grace and providence we are here to witness the commencement of another legal year. At this point, let me congratulate my Lord, the Chief Justice of Nigeria, Honorable Justice Walter Onogo, GCON, on his proactive steps he is taking profile of our judiciary and the judicial system since his appointment as the Chief Justice of Nigeria on March 7, 2017. My Lord, I speak for the Nigerian Bar when I say that your various initiatives, clear directives, and public pronouncements have all demonstrated a strong resolve that your tenure will be marked by the emergence of a bold and courageous bench, and that our judicial system will be more humane and institution. The commencement of a new new legal year offers us another opportunity to reflect on the challenges of the past, review the strategies we employed to confront them, celebrate our successes, appreciate our limitations, and then project into the future with a view to improving on the present indicators. This year's occasion cannot be different. As judges and lawyers, today's ceremony therefore offers us another opportunity to rededicate ourselves to the rule of law, which has been generally acknowledged as the enduring basis for the sustenance of democracy and constitutional order. I am happy to observe that in order to enhance the independence of the judicial and legislative arms of government and enable them play their constitutional roles in a more robust manner, His Excellency President Muhammadu Buhari earlier in the year assented to the fourth alteration to the 1999 Constitution, which amended Section 121 of the Constitution to provide that monies due to the judiciary in the annual budget should henceforth be paid directly to the heads of the court, and that of the legislature also paid to the heads hereof. This alteration, without doubt, finally answers the need to have more independent and impartial courts at federal and state level that will certainly advance the cause of rule of law in our country. I am happy to further inform you that in response to advocacy of the concerned stakeholders, the federal government is currently in the process of constituting and implementing to monitor the institutionalization of this revolutionary step in order to ensure that its good intentions are not truncated by the state level. Today, our country faces another cycle of potential legal contests arising from opposing political and constitutional views among political practitioners, particularly as we approach the 2019 general election. In view of the judicial role as the ultimate arbiter of disputes in a democratic polity, there's no doubt that our various courts, including the Supreme Court, will be required in coming days and months to urgently and equitably adjudicate on various matters involving the interpretation and implementation of the Constitution and other laws, and having potential impact on the sustenance of our national values and sanctity of our political system. I trust that in this endeavor, our courts shall continue to dispense justice in fair, firm, and courageous manner in the overall national interest. We are all encouraged by the speech of His Lordship, the Chief Justice of Nigeria, on Tuesday, 18th of September 2018, during the opening ceremony of the annual Federal High Court Judges Conference, where he had in sustaining and invigorating our democracy. I'm to once more acknowledge and appreciate the resolve of the leadership of the judiciary to advance the present agenda in tackling corruption and terrorism through the establishment of a monitoring committee. Judges, as far as humanly possible, expedite their handling of such cases in the overall national interest. I should also say that increasing deployment of technology by the courts as led by the Supreme Court, including in matters such as in service of processes, will assist in expediting the pace of justice delivery in Nigeria. I urge you, my Lord, not to rest on your oars. Let me, however, hasten to add that as we jointly take this giant step to tackle the issues surrounding the adjudication of grand matters such as political matters and cases of grand corruption, terrorism, and the likes, we must equally continue to take hard look at the quality of justice at the lower rungs of the ladder in our magistrate courts, area courts, district courts, and even high courts in far-flung locations of our country who operate oftentimes under very difficult conditions. Given the socio-political structure of our country, There are thousands of litigants and accused persons whose only contact to the judicial system will be at such lower level, who will never have the chance of approaching the appellate system. As stakeholders with our various responsibilities, we must resolve not to leave such persons behind, even as we push the grand reforms within our superior courts. The firm and fair resolution of contending social issues by our courts is critical to the continued confidence of our citizens in the efficacy of democracy and its capacity to resolve the challenges which they face on a daily basis. To achieve this, there is a need for all the arms of government to remain focused on improving the judicial system to a level which benefits us. In this context, my Lord, let me assure you of my continued commitment to a policy of responsible cooperation with the judiciary as the Attorney General of the Federal. I take to exert my utmost. All executive branch institutions always acknowledge and respect that judiciary is pivotal in the maintenance of law and order, and must therefore be fully supported to discharge that mandate. In achieving our goal of a more human and efficient judicial system, permit me at this stage to respectfully provide the suggestion that it may be time for our judiciary to take a second look at the current annual vacation. While the practice of a 2 months plus annual vacation is some part of our judicial system, it will appear that several litigants and persons outside the legal system including see this practice as a contributory factor to the delay of cases in our courts. In their estimation, it amounts to practical shuttling down the entire judicial arm for such a long time every year, in addition to public holidays and also applicable to the judiciary. While courts have historically tried to address this concern through the use of judges, we all know that vacation judges have their limits in some other jurisdictions. The practice of staggered vacation is increasingly as a strategy the need for rest and data shutdown of the judicial extended periods. My Lord, I proffer this opinion confident of the capacity of the judicial arm to constantly renew and transform itself through a periodic review of its system and processes. I hope my suggestion will therefore be treated as an input to the internal process. I now turn to congratulate our new senior advocates of Nigeria just sworn in today. I am convinced, considering your years of toil and labor and the painstaking selection process through which you are deserving of this eminent rank. I therefore charge you to remain shining light in the practice of law within the house. However, hasten to add that there are corresponding duties and responsibilities that go with your new. A senior advocate of Nigeria has a duty to exhibit the highest form of decorum, discipline, and dedication to the cause of justice and fair play. As a leader of the bar, a senior advocate is expected to bring to bear on the profession high standards of diligence and honor in the conduct of his cases. Let me hasten to remind you that your new status confers no immunity from the disciplinary processes of our profession or of the law for any act of misconduct. However, trust that you shall not be found wanting in meeting the high demands of your new ranks. My lords, distinguished colleagues, ladies and gentlemen, in concluding my address, may I thank my Lord, the Chief Justice of Nigeria, once more for the kind invitation to be part of this ceremony. I look forward with enthusiasm to a glorious year ahead, and urge us all to work towards the entrenchment of the rule of law in all aspects of our national life. I thank you all for your attention. Signed, Abubakar Malami, Senior Advocate of Nigeria, Honorable Attorney General of the Federation.
Thank you very much. May we hear from the representative of Learned Senior Advocate Chief R.O.A. Akinjide on behalf of the body of Senior Advocates of Nigeria. Yes, Chief Okoko.
Thank you, my Lord. Chief Akinjide sent his apologies. He said that he specifically mentioned it, that he could,
Yes,
but with an undertaking that he will do his best at the next one.
Okay.
My Lord, the Honorable the Chief Justice of Nigeria, Justice Walter Onoge, please permit me to rely on the protocol which the learned Chief Justice of Nigeria has established. This annual special session of the Supreme Court, held to mark the official opening of the legal year of the Apex Court as a whole, and admit to the inner bar lawyers who have attained distinction in the legal profession as a judge by the Legal Practitioners Privileges Committee. The ceremony also provides an opportunity for the body of senior advocates to make its comments and observations on the working of the justice sector and to put forward suggestions designed to enhance the administration of justice, matters connected therewith, and also to welcome their new colleagues. The ceremony has come at a critical point in a time in our nation. Contest for political offices is just a few months away, and already political gladiators are at it again. Instead of considering and adopting and debating real issues and challenges facing the country, valuable time is being wasted on semantics and accusations and counter-accusations. In this way, the real problems of our country, the real problems in our body politics have been sidelined. Before, during, and after the conduct of the elections, unsuccessful parties will head for the tribunals and the courts of law for redress. That the bar will be recruited quickly to fight the war for political office, even if the facts did not add up, did not justify such a war. Many colleagues will see nothing wrong with rendering advice or opinion on the case of their clients, which they know the facts presented cannot support. Now, what is generally referred to as juicy brief. Some of us will resort to distortion of facts and labor to manufacture evidence, or resort on as fake news or fake evidence. Some will boastfully assure their clients what their client's case, such a case is patently groundless to their knowledge. Instead of telling their clients truthfully and honestly the legal effect of the known facts of their client's case, they proceed to fix ridiculous and outrageously high fees, high sums of money as their professional fees, and sometimes do so on the basis of their assertion that there are special ways of winning a bad case otherwise than by advocacy as known to the profession. In the process, a supposedly honorable gentleman of the bar may be forced into resorting to the practice known to the Roman advocates as suppressio veri and suggestio falsi. These are not actions or conduct expected of a member of the noble profession of law. Those of us who resort to such objectionable practices as a means of making it a noble are harming not only the noble judges of our courts of justice and their colleagues, they are indeed hurting the of law, which they join on their own volition because of the honor, dignity in society, which our predecessors in the profession have practiced. Rendering honest advice, it is a disservice and to society as a whole for any bar to knowingly render wrong or dishonest opinion or address on a point of law in law or unsustainable bears the consequences of its needs on the spot. A counsel deliberate to delay or frustrate the hearing of a case is regarded sufficiently serious to earn an erring counsel the necessary sanction. Lawyers must appreciate that the services provided by the judiciary in our nation benefit of litigants fortunate enough to know what it takes to attract investment into the country for development. We readily acknowledge the fact that investors, especially foreign investors, first deciding whether or not to invest in the reliability and efficiency of the judicial system of the country. This is because the investor wants to be assured that in case of a commercial dispute, there is in existence a reliable and efficient court system manned by judges of undoubted integrity to resolve the dispute. Whatever happens on the bench or at the bar cannot remain a secret anymore. The world is now a global village, and all our activities in private are being watched all over the world. I referred to fake news just now, and I want to relate it to what I read of what was reported of what the Chief Justice of Nigeria said recently. Fake news is now exists in reality. In the Vanguard newspaper of Wednesday, the 19th of September 2000, the Chief Justice said, "Courts will ensure that political cases are determined limit determination on the merit to political cases." That is one pass for fake news. It purported to be a quote from the address delivered by the Chief Justice of Nigeria at the 34th Annual Conference of the Judges of the Federal High Court. Let me hasten to add that the Learned Chief Justice did not limit what the paper ascribed to his lordship to political cases alone. This is manifest from the other parts of the publication, where the Honorable Chief Justice of Nigeria was correctly quoted to have said, and I quote, "While INEC has the responsibility to conduct and manage elections, the judiciary on its part is charged with the responsibility of resolving disputes arising from the process. We must therefore ensure matters brought before are determined any external influences to ensure the sustenance of independence of the judiciary. It is therefore misleading for anyone to assert or suggest that only political cases are to be determined on the merits by the courts." To our colleagues of the inner bar, I congratulate you for your well-deserved honor of being elevated to the inner bar. As I said in 2015, as I said in my 2015 speech in this court, A senior advocate of Nigeria is an aristocrat and a legal practitioner of high ranking. Your recognition as a member of this elite group imposes on you the status of a leader at the bar. People will look on you from today henceforth as a special lawyer. And because of your new status, expectations of good conduct expected of a gentleman at the bar will be very highly demanded of you. The of any conduct unbecoming of a gentleman at the bar on your part will raise great alarm in the minds of reasonable members of the Nigerian society, who will see you as a bad example to young lawyers and a bad role model in society. You must therefore take to heart that your new status imposes on you the duty to be honest, truthful, and just in your practice of law and in your everyday life. The oath you signed this morning is there for you to read all the time to remind yourself that those to whom honors are granted, much is expected. The new status as a senior advocate of Nigeria is not a license for you to corrupt and encourage the corruption of judges in any manner whatsoever. You must know that it is not only the giving or taking of bribe that constitutes corruption. Influence peddling is as much an act of corruption as the giving of bribe. Peer influence is another example if used as a means of securing an undeserved advantage or promoting or aiding unjust courts of law. Telling clients that you are in a special relationship of sort with a judge or the friend or relation of a judge as a means of securing a brief is a corrupt practice. Or telling a client that you can pass money from a third party to a judge, or that you know a person through whom the judge can be reached, are all grave acts of misconduct which unnecessarily cast a shadow of corruption, not only on the particular judge, but on the judiciary as a whole. Do not give our judges the name they do not deserve. Do not feed your clients with falsehood. Do not invite or advise your clients to reach out to any judge. That is not the way the legal profession. You are all lawyers of standing, and you understand all these things. Senior advocates in particular must not, by their acts and style of practice, be seen to aid or encourage corruption at the bar or on the bench. We must join hands with our justices and judges as they strive to build a judiciary that is efficient, corruption-free, transparent, and of which our nation can be justifiably proud. Once more, I congratulate you all. My Lord, the Chief Justice of Nigeria has alerted judges that their courts are likely to be flooded with litigation bordering on pre-election and post-election matters. Following from what I have already said, many senior advocates will certainly participate in these matters. I do not intend to discourage anyone in taking up these practices, especially the juicy ones. In fact, I encourage lawyers to take up these matters. All that needs to be said is that in the discharge of your duties in these matters, you should not be swayed by politicians to say white is black and that black is white. When lawyers stand firm on due process and the rule of law, our judges achieve the just determination of the cases before them. In election petitions, politicians who prosecute and defend these cases easily point to corruption as a reason for any adverse ruling against them, whatever the merits of their case. It is therefore necessary to remind our colleagues that their lordship will conduct and hear these cases of the need to be consistent in the law they administer and not to allow any politician or litigant obstruct their view of justice. Nigeria needs our judges now more than ever. The ability of the nation to survive the election year and still remain as one nation is in the hands of our judges. May the good Lord, who placed us together where we now find ourselves and made us neighbors, release to our judges at all levels wisdom, courage, and justice to save Nigeria for us all. Finally, my Lord, let me refer to 3 brief things of practice which may assist in future. The practice I met at the bar in 1971 when I was called is that whenever an appellate court decides a case, a copy of the appellate judgment is served on the judge whose judgment gave rise to the appeal. I consider this practice very beneficial. A judge who reads will appreciate why the judgment was overturned or was supported. That will make him a better judge in other cases. I appeal to the Chief Justice of Nigeria to reinstate the practice for the benefit of the profession. A trial judge will not wait for a law report before reading the appellate court views of the judgment. The second, that there was a time when supporting judgments or dissenting judgments in appellate cases was a matter of common experience in the appellate courts. My Lord, reasons supporting judgments and reason dissenting judgments appear to be vanishing from the scheme of things. A reason supporting judgment or a reason dissenting judgment both throw light on the main judgment of the court. In any way, this supporting judgment or dissenting judgment helps to deepen our knowledge of the law and the basis of the court decision. I appeal on behalf of senior advocates of Nigeria to your Lordship that the practice should not be allowed to die. Courage as a welcome development, practice of law. Finally, your Lordships have said without time, without number, that the Supreme Court is supreme, not because it is infallible, but because it is the final appellate court. The position of the Supreme Court has not changed. The challenge this time is to us at the bar. The position of the Supreme Court has not changed. The challenge for the Nigerian bar or the Nigerian legal community is that there is no bar journal of standing to publish reviewed judgments of any of our courts. Your Lordships will also learn from the views expressed in reviewed judgments. A properly organized publication of the bar journal is a vital material and have a publishing outfit of a standard high enough Nigerian law journal, where intellectual articles and reviews, not only of judgments of court, but also pending bills and enactments, can be articulated for a better